Good morning, sir.
Good morning, Your Honor. May it please the court, my name is Brian Michael Olmstead. I am pro se, dealing with the opponent, the Commonwealth of Massachusetts, in the form of the Department of Telecommunications and Energy.
Cable.
I am not going to repeat the matters that are already in my brief as to the appellate route. I think that that is clear and established that properly the initial order of the single justice sending it to the Superior Court was proper. I would refer the justices to the appendix in the Commonwealth's brief in which they contain the regulations for the Department of Telecommunications and Energy, stating that certain portions of those rules apply to the Department of Telecommunications and Cable.
What could you tell me exactly what you're referring to?
Yes. I am referring to page 68 in their appendix, which is Rule 1.13 of the Department of Telecommunications and Energy, and the earlier pages state that that's one of the rules applicable to the Department of Telecommunications and Cable. That states, appeal from department decisions. The department shall notify all parties of their right to appeal a final decision of the department pursuant to Mass General Laws, Chapter 25, Section 5, and of the time limits on their rights to appeal. That never occurred in this case. There was no such notification from the DTC with regard to any order that it issued, including the final order. Rather, it stated that the right to appeal was any avenue under state and federal law.
Well, appropriate, I think was.
Pardon?
Appropriate avenue, didn't it say?
Well, I don't think they were suggesting anything inappropriate.
No, but yeah.
Therefore, there's only two logical consequences. One, that was the route of appeal as argued by the Attorney General, but the agency, instead of meeting its duty to give me specific notice and of the time dates, decided not to. And as a consequence, that is a denial of due process of law. Or alternatively, the Attorney General's position is unfounded and the agency was doing what it did in every telecommunication case that came to final order, namely stating the right of appeal was under appropriate fate or federal law and made no reference whatsoever to Chapter 25, Section 5. That was confined exclusively in the final orders to cable TV under Chapter 166. That was the actual practice and interpretation of the agency since its existence in 2007.
I'm sorry, what was the actual practice?
Namely, that when you were under Chapter 166, Community TV, they gave the notification of appeal under Chapter 25, Section 5, as is in Chapter 166. That's what they always did. When it was under Chapter 25C, Telecommunications, they did not. They instead simply stated the right of appeal was under appropriate state or federal law. As a consequence, to me, the court will decide it either way, but in either way, either I'm properly before this court because due process would waive timeliness of something I wasn't notified about, and you will hear the merits, or I'm properly before this court on an appeal from a single justice that has dismissed the case, and the matter should then be sent to the Superior Court under the Administrative Procedure Act. I stated that explicitly in my brief, that while I preferred the first alternative, I think the law is sounder that this is under the Administrative Procedure Act. I rather than move to what is the essence of my argument here on the merits. The determination by the DTC was that the matter is moot and there is no possibility of my obtaining any relief in any further judicial proceedings. The mootness issue requires the court to then examine whether that is a sound decision, and as a result, there is no reason to send a moot matter along. I submit to you that analysis of that reveals the heart of the objection that I have made, namely deceit by the DTC and Verizon Communication completely permeates this case. And it is that deceit leading to a dismissal claiming something is moot when the rule itself expressly says the only sanction for not obeying an order to pay is that you can be terminated prior to the hearing, and you still have the hearing, and it has a further provision where someone who is terminated can then return for service within 6 months in order to resume service. I step back on this because it is necessary to see what the rule's real import was. It was primarily a device for poor people to prevent having to deal with the effect upon them by sudden and dramatic termination of gas, electricity, or telephone service, an endemic problem for the poor. The rule as it exists initiated back in 1977 with the Department of Public Utilities promulgating a rule that ultimately was codified in regulation. That existed because of the lawsuit pending in the United States District Court by Legal Services against the Commonwealth of Massachusetts and the Department of Public Utilities and all utility companies, claiming that the effect of their operation is shutting off vital services to the poor with no opportunity to be heard.
But could I just ask a question about that? I mean, I'm looking at Rule 6.2
Yes.
on page 95, which I think is what you're referring to, or maybe?
6.2, that is, 6.2 is the one with the complaint procedure.
Yes. Isn't that what you're talking about?
There are three elements of the rule that are implicated here that were vital. The first is at the beginning, full disclosure as to all charges, so that people could intelligently decide just what it is that they were going to buy. The problem with the poor is they suddenly get hit with a huge bill. They can't pay it. If it isn't paid in 25 days, they're shut off. The second was a prohibition under Rule 5 that you cannot even threaten termination of service if there is a dispute under Rule 6. Not only you can't shut off, you can't even send out a threat. And finally, Rule 6 provides that there must be informing everyone in the bill, which is in the administrative record. The first bill that was received has directly a page dealing with right to dispute a bill, which is what the rule provides. That says you can contact the company, telephone company, by phone or in writing. They are to investigate, and the key provision is they send you written notice of the results. If you're dissatisfied with them, they send you written notice of your right to appeal to the agency. That's what it must say. That's what triggers then most appeals. If someone does appeal it under the rule, under the regulations, the department has the ability to informally look at this, make recommendations. But if dissatisfied, at that point, the individual can take a further appeal for a Chapter 30A adjudicatory hearing.
But where is that in the rule? Oh, before, is that in 6?
In Rule 6, yes.
Okay. And
And
then-
6.2.
Yes, I see that, or 6.1, I think. But that doesn't tell you where the appeal is going to be from the adjudicatory proceeding, right?
Pardon?
You can take a 30A appeal before the agency, right?
Yes.
But the rule doesn't explain if a party aggrieved by the decision of the department where it can take its appeal, or he can take his appeal, right?
Correct. Commonly, that's simply if there is no relief and you're aggrieved, what the company does is shut you off. They're not looking for any agency authorization whatsoever. They're going to the agency is to stop that consequence. It also provides, under Rule 6, Section 3, that anyone can directly claim an appeal for an adjudicatory hearing for any issue under the rule, which is actually how this matter started. Because Verizon Communication never responded with a letter saying they had a right to appeal, even though they received something like 14 written complaints, never once. As a consequence, the only way of formally invoking the agency was under 6.3, a direct claim to the agency demanding an adjudicatory hearing. When after the first contact to the agency in June of 2009 with threatened shutoff, the agency did nothing. When actual shutoff occurred in December of 2009, what was filed with the agency was a direct claim of appeal and a demand for an adjudicatory hearing. The agency did nothing. Finally, they did something in April, docketing the appeal, sending out notice. The immediate response of Verizon Communication was within 5 days to again shut off the service. And again, there was again an appeal there. So as a consequence, that reflected, one, the agency never enforced the rule. Two, the agency never regulated Verizon Communication. When you look at the two orders that entered on the same day, December 10th, the commissioner is saying, A, the direct written claims against the DTC that were filed will not be heard, even though we claim you're not enforcing it at all and you're not regulating the actual operator. They said your allegations with regard to misconduct by the agency will not be considered. Your claim that you're not regulating Verizon Communication will not be considered. They have nothing to do with the telephone company. They are cable TV and internet, not the telephone company Verizon New England. That's the ruling by the commissioner. On that same day, the hearing officer rules on the basis of a cryptic comment by counsel in opposition to my motion that they have now learned for the first time that Verizon Communication is actually providing all of the services to the telephone company under the billing and termination rules, learning it for the first time. And therefore, with that new insight, which the commissioner is trying to say, we don't know that that's going on. But the hearing officer now knows it because on November 26th, I believe, or the 27th, that was a memo that they filed. I immediately filed the next day a motion to strike. That was denied. That became the basis to say Verizon Communication is now running things. You receive bills from them. You didn't pay them $24.01 a month. We are shutting off your service. The order went out within approximately 15 minutes of the electronic order before I even knew it occurred. They shut off the service. Now, the other thing that I'm trying to communicate is this was a telephone matter. When door-to-door people came, knocked on the door and said, we can sell you a product cheaper than Comcast, the competitor. That was the provider at that time. And they wanted to sell it to me because they had installed all the original wiring and wanted a return on their investment. I asked about all of the charges. They said, no. Simple offer, $99 a month with telephone. $89 without telephone, with telephone, $99.99. That's it. The first bill arrives, finally, after installation, and then things start in February, and lo and behold, there are all of these undisclosed charges. And so the first written complaint is made in April. The consequence was the first contact with the
Mr.
DTC.
Olmstead, I have to tell you, your time is up, so you're going to have to wrap it up.
Okay. I'd ask this court to make a series of rulings, namely that it is a legitimate claim against an agency under the rule if the agency itself is refusing to enforce the rule. 2, to make a ruling that they had to examine regulating Verizon Communications, the non-license holder in this case, and whether or not they can be permitted and what kind of controls are there. 3, since what's vital is disclosure of what things are going to cost, that implicates Chapter 93A and especially the 93A regulations that deal with things like door-to-door sales as to what is the truth. To be guided by the standard of 93A, thou shalt not deceive, rather than, as Verizon said in their writing, their policy is disclaimers that we're not telling you anything about prices.
All right, sir, thank you.
Then send it to the Superior Court for then instructions as to how to proceed. Since if we go the route of the matter should go to the Superior Court, the court has clarified the legal setting of it. The Superior Court, under the Administrative Procedure Act, has the authority to even hold evidentiary hearings in order to flesh out the record. That's my request.
Thank you.
Good afternoon. May it please the court. Zuleikan Walker on behalf of the Department of Telecommunications and Cable. Here in the courtroom with me is Attorney Moore. As the court knows, Verizon adopted the brief of the Attorney General in this case, so I am prepared to take the full 15 minutes. However, if you have any questions you'd like to direct to Verizon, they are represented here.
Could you explain how this is supposed to work?
The regulatory
Yes,
scheme?
I'm a customer, I have a problem.
And this department regulates telephones, cable, right?
Correct. I guess I'm not, do you mean, are you
As
talking about the rules or the?
How it works, when you've got broad authority, and I take it on the merits, it's only dealing with telephones, but how does it work procedurally and substantively?
Okay, I guess I'm not entirely maybe
A
understanding the
customer, I
question.
have a problem about my bill. I think
Okay,
I'm calling you, the agency.
yes, you get the right initially to an investigation into your complaint.
That's Rule 6 point something or other?
I can't cite you to, it is in my brief, I believe, cite you to the particular rule.
Is it the part that's called, is it under this thing that's actually a DPU 18448? Is it under there?
Well, the telephone procedures are that provided a right for him to get an investigation, and subsequently, if he disagreed with the outcome of the investigation, he was entitled to an adjudicatory proceeding, and he was provided with that proceeding. I don't think there's any question here that he didn't understand he had a right to an adjudicatory proceeding.
But those are the rules that apply, that are in your brief starting at page 73, is that right?
Yes. But with respect to, let me just turn to 63. Mr. Olmstead's objection to an accusation that the department's failure to include in its final decision and notice of appeal a reference specifically to Section 5, Chapter 25, I do, if that's sort of where you're probing, want to address two or three important points on that. First of all, the 220 CMR 1.00 does expressly provide, was adopted by the Department of Telecommunications and Cable.
Where does that appear in the record?
Okay, so on page 50 of my addendum, it says 220 CMR, and that it says DTE. This is on the website. And then it says underneath it, sections applicable to the Department of Telecommunications and Cable.
Okay.
He has cited to 220 CMR 1.13, which does suggest that the department in its notice of appeal should reference Chapter 25, Section 5.
Suggest, it says it shall.
It shall. But I do want to point out that another provision in this regulation, there's two other very important provisions. One is on page 52 of the addendum to my brief, which provides the department with the ability to waive its compliance with these regulations for good cause, and that's 1.01 subsection 4 on page 52.
And what is the good cause for not giving
Yeah.
him notice
Yeah.
that he
In
has a
this
right to
case,
appeal?
The good cause, from the department's view, is that many of the decisions that are disputes that are brought before the department are governed both by federal law and state law. The view was that in this case, it was potentially misleading to cite specifically Chapter 25, Section 5, if in fact other avenues of appeal were available under federal law.
Any notice
Now-
given to Mr. Olmstead that you had good cause and were waiving the provisions?
No, but there is another provision that I think is very important that I want to cite to the court, and that is that on page 67 of the addendum to my brief, Mr. Olmstead is notified in the department's regulations, in the provision for, it's titled Rulings, Briefs, Oral Arguments, and Post-Hearing Procedures.
What page is this?
You said 67.
Yes, addendum page 67. It's 1.11 subsection 11. It says extensions of judicial appeal period. And it provides notice to Mr. Olmstead that any appeal, first of all, it says, references specifically Chapter 25, Section 5, and that any appeal from the department's decision must be made within 20 days after the entry of the order.
Then you didn't waive the
The
rule.
notice that section
No, absolutely
1.13
not, Your Honor.
requires?
No, I do not. I'm simply saying that, first of all, I want to advise the court that the department will be changing its notice of appeal. So that's going forward certainly going to happen. But I'm simply saying that as a matter of constructive notice, he certainly was aware that Chapter 25, Section 5 applied to these proceedings. If you look at the regulations, Chapter 25, Section 5.
You just said you'd waived that. I mean, you can't have it both ways, Ms. Walker.
No, what I said was it waived the provision on the final, the 1.13, that on its notice, that its final decision and its notice of appeal, that it was required specifically to reference Chapter 25, Section 5.
Well, we're going to hold it to you, but we're not going to tell you, and we're waiving it, and there's good cause? That's what you're saying?
I'm saying that it's not a matter of us holding
Yes,
them
you are
to it.
holding him to it.
No, the jurisdiction provisions in Chapter 25, Section 5 are. And I know of no rule of this court that even if you were to find that the department's, that there was no good cause, that the department's view was not satisfactory, I don't know of any rule that says that the department's failure to comply with 1.13 or one of these regulations can confer jurisdiction.
So the AG is saying, with regard to almost entirely unrepresented consumers, that although we did not tell you you have a right of appeal, we go to the single justice, and the time limit, even though we, in our regs, say we must do so, that you then go to the single justice and say, he did not file timely within that, with regard to that provision, therefore it must be dismissed, and you have no choice but to do that? That's what the Attorney General is saying is to happen to unrepresented consumers.
I'm saying that 1.11...
The yes or no, is that what you're saying?
No, I disagree with the characterization. I think that there is a distinction between saying that there's no notice given by the department and saying they failed to include it under 1.13 on the final decision.
So the underrepresented consumer is supposed to sort of make reference to this 1.111 and say that constitutes the notice, even though they didn't give me the notice that the CMR says they must give. That's what you expect consumers to be doing.
The department gave them notice that there was a right to appeal under state and federal law. I don't think this is fairly, it certainly wasn't misleading. I mean, the notice said you have a right to appeal under state and federal law.
And
This is,
the single justice, at least initially, thought that meant you had a 30A appeal because that's actually a hard question.
Well, and we can certainly, yes, address that. Initially, the single justice did transfer it to under 30A, but when it was pointed out and that there had been a reorganization and a citation to 166A Section 2, the understanding was the single justice then understood that actually this was governed by Chapter 25.
If it's confusing enough that a single justice errs, don't you have an obligation to be clear for an unrepresented consumer?
Your Honor, I certainly think so, and that's why I'm representing to the court that the department is going to be changing its notice. But I don't think that can confer jurisdiction, and for that reason, the single justice's order must be affirmed.
Let me ask you this question. Is there any remedy? Let's assume that we don't agree that there was good cause for you to silently waive the provision that you shall notify the consumer that the appeal is under 25.5 and he has 20 days. Let's assume there's no good cause. Any remedy for that?
No,
Oh,
unfortunately.
I see.
But I also...
Other agencies do have remedies when they can't follow their rules that courts impose, that we can't do anything
But in
this
those
way?
cases, as far as I can tell, Your Honor, I haven't found a case where that was the situation where there was a jurisdictional limitation here. But I
what about
also
a late
really...
filed appeal? Nunc
Excuse
pro
me?
tunc.
Sorry, say again?
What about a court issuing an order that the appeal could be nunc pro tunc?
So waiving the jurisdictional limitations of Section 5? I don't know of any precedent for that, Your Honor. And I also do think, the notice was at least constructively provided in the regulations. I agree that it was certainly not ideal, but it's not like the notice that went out was misleading. It simply said you have a notice of the right to appeal. We do expect more. The department will be giving more. But this court consistently in Eastern Energy and in Department of Utilities versus Attorney General has said that these provisions in Section 5 are jurisdictional limitations. And I haven't been able to identify a situation where an agency's violations of its own regulations can override that. I would point the court to the case of Curley versus City of Lynn, 1990 case of this court, which is the only case I could find that was even remotely on point. And in that case, this court said, and it's 408 Mass 39, that in the absence of statutory authorization, the commission, in that case it was the Civil Service Commission, through its hearing rules cannot modify statutorily prescribed time limits on judicial review. Not exactly on point, and I realize that, but I was unable to find anything directly on point. But it does go to the issue that in that case, the Civil Service Commission's rules had left the impression that the party, through motions for reconsideration of the commission's decisions, could extend the appeal period. And this court said no.
Well, in this case, we're actually reviewing the single justice's decision, right?
Correct, yes.
To determine whether he committed an abuse of discretion or an error of law.
Yes, Your Honor. And my view on the statutory interpretation issue in the language of Chapter 166A is that Mr. Olmstead's interpretation of the language or the statutory scheme here would be contrary to common sense as well as historical practice. Mr. Olmstead's interpretation would mean that this court would have to find that the legislature intended for all cable decisions, all other utility-related industry decisions, with the exception of telephones, would be going to the county court, and that for some reason the legislature would intend to change decades of practice of sending appeals of decisions concerning telephone service providers and send them to the Superior Court.
Could I just ask you a question about that? Because Mr. Olmstead said at some point in time, or at least I think he said, it was the case somewhere in history that appeals from consumer complaints did go to Superior Court. Is that correct? Or were they always governed by 25.5?
It was always governed by 25.5. There was an exception for cable rate decisions under Section 166A, Section 15, which was the case that came before you on the City of Springfield case. That's the only situation I know of where there were decisions that went to the Superior Court. Since 1953, all other utility decisions went to the county court. So although it is, I understand, very unsatisfying to say to you that there's no relief in this situation in light of the notice, I think that the Chapter 25, Section 5 does govern. It's the only way to render a common sense reading of this statutory scheme. And in that respect, this court at least twice has held that a failure to comply with those provisions in Section 5 require dismissal of the appeal. And for that reason, the single justice's decision should be affirmed.
Was the single justice informed that the department had arguably violated its own rule by failing to give notice?
I don't believe that was briefed, Your Honor, no.
So how can we say that he considered that if the AG did not bring that to his attention? And does not the AG have an obligation to inform the judge that there is a CMR which required us to give this notice in the time limit, and we didn't do that? Isn't that part of what we expect you to do?
Well, I think that, first of all, begs the question of whether or not it was a violation. I think that the view that it was not misleading. There was notice that there was a
You didn't give the
hearing.
single justice the opportunity even to consider that because you didn't alert the single justice to the existence of that regulation.
Well, I wasn't counsel at the time, and I
I'm
understand
not
I'm
telling
standing.
you, but
Right.
doesn't your office have an obligation when there's a CMR that when you're basically asking a judge to dismiss for failure of timeliness, to inform the judge that there's a regulation which requires us to inform the litigant of the opportunity to appeal, which arguably was not followed here? Isn't that what we expect the Attorney General of this Commonwealth to do?
Well, I have two responses for that. One, Your Honor, is that outside of these proceedings, we have certainly advised the department that they should be making those changes. But with respect to your specific question in the single justice proceedings, my assumption would be that my predecessor counsel took the same position that I did, which is that this was a jurisdictional issue, that there was what the motion to dismiss was based on the fact that the county court had no jurisdiction. So getting to
But that's fine, but you didn't even alert the judge to that argument. The judge was not in a position even to know about this, so how could the judge have decided that jurisdiction holds despite this regulation when the judge didn't even know of the regulation?
I don't perhaps have a satisfactory answer to that, except, again, repeating that in our view, this is not, there was a waiver provision that applied. There was notice actually given as a sort of constructive notice matter. The step was not taken. I'm assuming, I guess, again, I wasn't counsel, but that was the view, that where there's an issue of jurisdiction, where there's no precedent that I could identify that says a failure to provide that notice would confer jurisdiction, that what was briefed was that question.
Well, we'll have to leave it there. Thank you very much.
Thank you, Your Honors.
All right.